So we're a little bit over on time, but we thought we would still take a few minutes to ask a few questions to the panelists who are on stage, and then we have a question for Holly and Suzanne. So we're probably not going to get to all the questions, obviously, that came through the inbox, but we'll try to email you back directly. Again, that inbox is tmwebinar@uspto.gov. Also, just as a general matter, we'd recommend that you retained an attorney if you have specific legal advice, questions related to specific legal advice. We'll try to answer your questions broadly, but we want to avoid giving specific legal answers. So Dave, this first question is for you. In your presentation, you discussed the bully factor. So for many independent inventors, the bully factor looms very large. What do you recommend for small entities or individuals when a large corporate bully with deep pockets infringes the trademark of the small business owner?
Oh, so when the bully is the defendant?
I think the bully would be the
usually it's the aggressor.
The bully,
Yeah. First of all, you can go online and search for trademark bullies. There are websites devoted to it. You can see who's on there and who gets a really bad rap and who doesn't. So you kind of know pretty quickly if you're dealing with one. As we saw in a lot of these cases, you've got to do your homework. Don't be intimidated by the fact that some big brand owner sends you a letter. I know I spent years doing that, but don't be intimidated by that. A cease and desist letter is not a court telling you something. It's someone whose opinion is you've gone too far and you need to kind of say, all right, let's see. Hire a trademark counsel. Make sure they know what they're doing with trademark stuff. Don't just hire lawyers who says, oh yeah, I do that stuff. Somebody I think said earlier, patent lawyers who dabble in trademark stuff. But if you do that homework and then sit down with your people and your advisors, your marketing people or whatever, it's like, is there a way to deal with this? Do we need to keep it? All those questions that we ran through, run through them all. Because the bully is difficult to deal with, but they're not unresponsive to a well thought out reply or proposal or that type of thing. You kind of got to get them off their bully pulpit as fast as you can. And I'm not talking about bully patent owners. I'm talking about bully trademark owners. I just don't work in the patent area. But I think if you follow all the steps, you try to charm them a little bit. Show them you're doing your homework. Show them you're not just jerking them around because they've got the resources to deal with that and you don't. And so the more you can just sort of, like the Nutella woman did, I mean, it just do that. But don't underestimate the power that the social media has on a bully.
That's a good point.
Yeah.
So we got this question from a third-year law student, and it's on artificial intelligence. So do you believe that AI has the potential to, one, streamline clearance searches, and two, help business owners answer tough questions and mitigate business disruption?
I can feel that. I'd absolutely think that AI can help out with clearance. I think it can make that process easier for lawyers. I do. I don't think there's any substitute at this point in how AI operates for human judgment and real world knowledge and knowledge of the law, but who knows what the future holds. And I don't remember what the second part was.
So will it help business owners answer tough questions and mitigate business disruption?
I mean, maybe. Yeah, I think if AI gets to the point where, we don't want AI doing the unauthorized practice of law, right? Because that's illegal. So, but if AI gets to the point where it makes those clearance cheaper for business owners, absolutely. I think that's a win-win for them and also for trademark lawyers. So.
Yeah, I would say when clients call me with a new mark, I try to educate my clients to have done the first cut, right? Did you do a Google search? Did you go on social media? Spend an hour of your time rather than an hour of my time on the clock to see if you find anything that looks like a problem, right? If you think it's a problem, it probably is, right? I mean, there's a common sense cut at it. And so I think to the extent you can use AI to help you with that first cut, absolutely you should do that. I mean, that's just another tool that's available. It's free. It is not a lawyer, though, right? I mean, it is not providing you with legal advice. So I would not substitute the AI for engaging or talking to counsel, but I absolutely would use it in the clearance process that you can do yourself, because that might help you figure out, oh, that mark is not available, let me move on to something else, and you've never even encountered $1 with your lawyer, right? So you should absolutely use it for that purpose.
So another question we have is, you discuss priority use, and sometimes the sender of the cease and desist letter may not know that they actually don't have priority use. So any tips in how you would research priority use? Is it Google searches? Is there anything else broader that they can do?
Archive.org is a great resource to look at someone's website, to go back to maybe before your date of first use and see if the other side's website already had the mark on there. You can hire a private investigator to look into it. I mean, you've got to look through the materials and really do your diligence. And if you're not sure, again, don't send a letter. Just wait till you're sure. Yeah.
All right, perfect. And then the last question for our panel, and then we'll go to Holly and Suzanne. How do you counsel brand owners who might get really kind of emotionally attached or invested in their brand? This is probably something you deal with on a frequent basis. How should they approach the trademark, and how do you counsel them to kind of navigate those waters?
That's difficult.
One of the first cases I had as a young lawyer, in the water industry, our client had infringed this other company's bottle, just did. And we're in this conversation, and I said, I asked the guy, a very nice guy, I said, why is this case is obviously very important to you? And he said, Mr. Gooder, he goes, I have 4 daughters. This bottle is my son. It was that important to him. So people do get latched on, especially, and it's not a small company thing. Big companies, CEOs can get all obsessed with what they think is the perfect mark. And I don't know, what's your...
I had a celebrity who wanted to create a makeup line and came up with a mark, and only this mark encapsulated what they were trying to embody in this product line, right? It was the only mark that would do. A screening search identified like a spot-on obstacle, and I was like, move on. No, this is the mark. And I was like, okay, well, maybe I'll do a full search, which is a more deep dive into evaluating availability of a mark. And I said, maybe I'll see if something else, changes my opinion. No, made it worse. And they were like, no, this is the only mark. Now, that was a client where we took an aggressive strategy. We went after that mark. And we had to do it in multiple countries to try to clear the way for this client's mark. Now, that client had the money, right? So, I mean, if you're not going to be flexible in your mark when you were told that there's an obstacle, you better have money ready to either defend your position or, sometimes, clients buy marks, right? I've had I've been called, hey, your client has this mark, I can't find it in the marketplace, would you sell it to me? Right? So it might be available for sale, right? That business may have been gone. That individual may have, they started a clothing line, they've moved on to another business, they're not interested in it anymore. So you might be able to buy it. It may not be that expensive. You can always explore that, but really, to me, it comes down to money. Yeah. If you're going to be passionate about it, you have to pay for it.
Okay, so our next question is for Suzanne from Customs Border Protection. Could you please provide a brief overview on the steps that CBP takes when counterfeit goods are intercepted at the border? What are the specific steps that an officer would work through, and how does your office counsel those officers?
So I'm not going to go through the whole targeting stage, but essentially when a CBP officer is examining a shipment and they pull it aside, and they'll go, they'll obviously look at the merchandise, and then they will go on IPRIS, the internal site, to check for a protected trademark or protected copyright. They'll make sure it's for the correct class of goods. They will do an assessment for themselves. I will first note that CBP has the competent authority to make the authenticity determination. This means that CBP is the one deciding if something is counterfeit or not. With that being said, we do try to reach out to right holders. It is our best practice to get right holder input. So this means that if there is any question on the authenticity of the goods, the CBP officer or someone from my branch, an attorney advisor, will contact the right holder, the point of contact that they included when recording the mark. So this means that sometimes you will get an email from either an attorney in my branch or a CBP officer, but this does not mean you will always get an email. However, if a seizure does take place, you will get notice of that seizure.
Thank you.
I say one thing.
Yeah, please.
If you're a new registrant or a registrant that hasn't done this, record your registration with customs. It's not difficult, it's not expensive, and maybe it doesn't ever snag anything, but it helps them do their job. We got monthly phone calls from agents saying, we picked this up, is this legit, not, whatever, help them make their decision. Just record, because it's easy.
Thank you. Yeah, do you want to?
This is Dawn Nelson from HSI, and I totally echo exactly what you said. And even if you are somebody who only does domestic manufacturing, record with CBP. Why? Because the counterfeiter is making your product outside the United States, and they're bringing it in through a port of entry somewhere, right? CBP needs you to record with them so that they know what to look for, so that they can take action. And if you're sitting here going, no, I only make it in the United States, that stuff's just coming in, and it's just coming in, and it's just coming in. So it's so important to record with CBP.
Yeah, the last thing I'll throw on that, if you get a call from customs asking for help, give it to them. Yeah. Don't sit on it for a week. We're busy, call them back. They need to move. The stuff has to move. And I can't tell you the number of times I've heard them express that frustration, and my own people who didn't get around to it, and a whole shipment got through. Not because it shouldn't have, because our people didn't get back to them. So.
Yeah, they're doing their work for us, so make use of it.
Make their life easy.
Yeah. Holly, so we've got 3 questions for you. The first is, say there's a registered trademark, but it shows up as a username on a social media site or online in some capacity. This seems to be a popular concern.
Yeah, we did receive a couple of questions, and I think an interesting concept that needs to be kind of addressed first is, when is someone really infringing your mark versus just using it? So in order to be a trademark infringement, there has to be a use of that trademark or a confusingly similar trademark in commerce. Well, what does that mean? That means the other side has to actually be offering goods and services for sale, or in the case of a nonprofit, they're rendering those services, okay? So merely using the trademark, even the exact same trademark as a username on Facebook or on X, now we call it, or any of these other websites, or even as part of a domain name. I saw a question about that too. That is not trademark infringement. Well, does that mean you're out of luck? Are there any options? Maybe. So there are other types of laws that could apply here. Now, how that's going to be treated by, for example, a social media site is going to vary, but there are these ideas about false association. So I guess the official name for it would be false designation of origin. So if someone is using your trademark in a manner that is likely to cause consumers to falsely believe that you're associated with, endorsing, sponsoring whatever that organization is, that can be actionable. So you might be able to find relief on that ground. The domain name thing gets a little bit more confusing. That's, again, that could be this whole other program on how to do domain name issues. But again, provided that they're not really, the other side is not actually using that trademark in a way where they're offering anything, it can be tricky. You know that Nutella example that was discussed? So that would be an example where it'd be like a false designation of origin, that people might believe Nutella was the one actually putting on the World Trademark Day and not just an individual fan. But fan sites are permissible. That is a permissible use of a trademark. So if you have a Nutella fan for example, username or as an avatar, that is, provided it's not being used in a way to sell competing products, that might be an acceptable use. We would call that, not to get into the legalese, a nominative fair use, but simply using the trademark to describe the product is not in trademark infringement.
Okay, and so I think the next question might be somewhat similar. So if you have a trademark registration, say for a clothing item, and that clothing item shows up in a movie, how would they enforce that right?
So this one is tricky. I've actually dealt with this before in the video game context. We had a client that had a product and someone was using that product in a video game. Now, when we're talking about movies and music, this is where you start getting into some of the First Amendment issues. And so there is a test that courts will rely on. It's the Rogers versus Grimaldi test. We really want to get into the details about how that trademark is being used. Was it necessary? Was it relevant? But you can still sort of, so again, I wouldn't say this is like going to vary, and this is something where you should definitely consult an attorney because it's a very niche area of the law. I would certainly welcome the folks on the stage to opine on this as well, but it really depends on what that use is, the extent of the use, how it's being used, whether it's a plot point or whether it's incidental. So you will see occasionally, sometimes in TV shows, particularly you see this on reality TV, they'll like cover up the labels and stuff just because they want to even avoid this appearance of a false association. So I think that's why I'll leave it at that. It depends. But I don't know, because you all might have some experience with this as well. Anyone on the
By
stage?
and large, the bigger production companies want to avoid that problem, so they will try to get permission or they're sensitive to a protest, et cetera. But I don't know what your experience is, Michelle, but the smaller the production company, either they don't know or they don't care.
Yeah.
Or they're just trying to be edgy. It's a tough area for brand owners, it really is.
It's such a niche issue that we actually have, like one of my partners, that's her specialty. It's like clearance. It's clearance. That's all she does. And it's, I mean, it's a nuanced issue, so you weren't kidding when you said check with a lawyer. Yeah.
Okay, so the last question, and it touches on international issues, which is something the Office of Policy and International Affairs team works on. But in this case, an individual has a registered mark in the United States. They were at a trade show in a third country outside of the United States, and somebody that they were meeting at that trade show ends up registering their trademark in the third country. Does the owner of the trademark registration in the U.S. have any rights to take action abroad?
I hate to hear the kind of cases. The answer is no. So remember that concept of territoriality. The scope of your trademark rights is the bounds of the United States. So having a trademark here, great, very powerful in court, doesn't necessarily give you rights in that third country. Now, does that mean you're completely out of luck? It depends. Now, you would have to, of course, you'd want to consult someone who is familiar with the laws of that country. As I mentioned, most countries around the world are what we consider first to file countries. So if they kind of beat you to the punch and they start filing the trade, or if they start using and registering the trademark there, you might be out of luck. But in this case, we don't know. Are they just using the trademark there, or have they registered it? Because you could maybe register it first. Could there then be a battle over first use? Yes. But again, it's going to be a very fact dependent. But the general issue is that territoriality means your rights are extended to the U.S. only. That's why it's really important that if you are working with partners abroad, like at a trade show, you're going to want to sign some sort of contract about their use and just be very careful. Same with manufacturing. You want to be very careful that your IP stays with you.
Is there anything that the trademark team in OPIA wants to add to that, or are you comfortable with that?
Okay. Yes, I have we also have colleagues here. Just so folks know, the way OPIA is organized, we are on the enforcement team, Amin and I. We also have experts in trademarks, copyrights, patents, as well as a team dedicated to China. So if you have any of these kind of issues, you can certainly send it to us, and we'll make sure to send it over to the appropriate subject matter expert.
Okay, so I think that wraps up questions. We have one announcement, which is that this session it was recorded and will be available on YouTube in about 3 weeks or so. So with that, I think we achieved all of our objectives for this session. We wanted to show you the importance of having a trademark registration, how you can use that trademark registration for enforcement, including with a recordation with Customs Border Protection, how to work with social media and e-commerce platforms when you deal with infringement. Jordan gave us a very thorough background as to the scams that USPTO is dealing with and how to address that and what to be aware of. And then Dawn talked through some of the criminal enforcement actions. We spoke to you about the importance of cease and desist letters, the civil enforcement process with John and our panelists on the stage. So we hope that this broadened out your understanding of how important trademark rights are, and they're a resource for you to use for your underlying business. So if you do have any follow-up questions, please do send us an email and we'll try to get back to you as soon as we can. But thank you for your attention and your participation.